Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathon Kappy.
And I'm Margarita, Grup.
Welcome to Hull on Estates. You're listening to episode number 681. Today, we are going to be discussing estate trustees during litigation and when they may or may not be appointed. So we run into estate trustees during litigation, ETDLs for short, and we see often circumstances where they get appointed. I think until somewhat recently, at least I was of the view that they were only to be appointed when there was a challenge to a will outstanding and you needed someone to administer the estate while this will challenge was playing out. The courts now have expressed a different point of view. So let's get into that in terms of when they can appoint estate trustees. And then maybe we can have a discussion about whether they should appoint ETDLs in all circumstances. So why don't you start us off?
As you mentioned, an estate trustee during litigation essentially is appointed by the court to assist with the administration of an estate. They can pretty much do everything except distributing the residue of the estate. And they take that role usually during the process of litigation, especially if the litigation is very contentious, although what litigation isn't. And the court has the authority to appoint an ETDL generally through Section 28 of the Estates Act. Or I think they have the authority also through Rule 71.06, sub 3, sub F of the Rules of Civil Procedure. And this was kind of covered in a decision from 2017. It was actually an endorsement on a motion on a case called Mayor v. Rubin. It was a 2017 case, ONSC 3498. And in this case, the applicant was seeking to appoint an ETDL to manage her father's estate until the litigation is resolved. The applicant was essentially one of four estate trustees. The other three estate trustees were the applicant's mother, Ida, and siblings. There was another respondent in this matter. She was a sibling as well, but she renounced her role as the estate trustee. So the mother, Ida, in this case, who was one of the estate trustees, apparently lacked capacity. And this was something that all the parties were aware of for a very long time. There's an allegation by the respondent's lawyer that she actually lacked capacity from 2004. So it's been years and years. This arrangement appeared to work for everyone else. Documents were just presented to her. She was just signing documents. She was signing checks, not really understanding, what she was signing or why she was signing that. This is important in this case because the estate trustees would have to act based on a majority. And if three of the responding estate trustees are, making all the decisions with one of them being incapable, it only means really that two of them are making all the decisions, and that wouldn't really qualify as a majority. This didn't really stop the estate trustees from proceeding with very substantial commercial transactions and questionable transfers of, estate assets. They were distributing, there were also some distributions made to the trustees from the trust funds. The estate trustees were having Ida sign off her funds over to them, and which essentially left the trust fund completely depleted. The applicant in this case was also asking the responding estate trustees to pass their accounts on multiple occasions. Somehow they, avoided doing that as well up until the date of this motion. Justice Myers, in his decision, essentially found that considering that all these reasons, it was necessary to temporarily appoint an institutional estate trustee to sort of provide an independent, transparent, and accountable stewardship to this very substantial estate. And I think the key here is the fact that it was a substantial estate. He concluded that because of the estate trustee's conduct, it was necessary to to immunize the assets from the parties' adversity and animosity while they fight out their battles. So the estate trustee, so the estate itself has to become neutral in the fight between the applicants and the respondents so that it's not impacted or leveraged by one party or the other. That was essentially the court's sort of bottom line on this issue.
Yeah, I think it's important that in this one, it really was about an accounting of this administration, right? You've got 4 estate trustees, majority rules. One is the applicant who clearly doesn't know what's going on, is asking for the accounting. And then you've got 3 of them who can act by majority, but one of them is Ida, who the court doesn't think is actually capable. And so through all this, for years, asking for an accounting, not getting documents, not seeing what's going on behind the scenes, the court is asked to put in a neutral person, and it's Justice Myers. And that will become important because Justice Myers also made the next decision that we're going to talk about shortly. And yeah, he talked about, he wanted to assure transparency. He wanted to let the people who are fighting fight and let someone neutral manage the administration, be transparent to everybody, and so that everyone can have their own role. He sort of says the estate shouldn't be involved in this, right? Let the parties who are fighting, let the estate be neutral, and let's put someone in neutral to do that. Now, one of the key takeaways for me was there was no challenge to the will in this case. The will spoke to who the estate trustees are. And, there's no disputing that the will was valid, that the appointments of the estate trustees were valid. What jurisdiction does this court have to say, no, I'm not going to remove people, but I'm going to put in a temporary estate trustee during litigation while this fight plays out, right?
Mm-hmm.
Because no one disputes that he can remove the estate trustees and just appoint someone neutral, but that's not what he was doing. He was putting in a temporary ETDL. So counsel argued that the limits of the court to appoint an ETDL were restricted to Section 28 of the Estates Act, which specifically speaks to appointing someone for a temporary period while a will challenge is ongoing, and also Rule 51 that talks about interim orders being made at a case conference. And so they argue that the court didn't have jurisdiction to appoint an ETDL where there is no will challenge. You can remove an estate trustee, but you can't appoint a temporary estate trustee during litigation. That makes no sense. Justice Myers felt differently. Justice Myers referred to the inherent jurisdiction of the court to control its own process, to ensure fairness between the parties. He started pulling from other cases that were not estate related in terms of the court's inherent jurisdiction to do certain things. He referred to the Stelco decision, which was a bankruptcy case, where the Court of Appeal talked about the inherent jurisdiction of the court is a virile and viable doctrine where the court reserves a fund of power and a residual source of power to do what's equitable as between the parties, particularly to ensure the observation of the due process of law, to prevent improper vexation or oppression, and to do justice between the parties. So Justice Myers is saying this inherent jurisdiction of the court gives the court the authority to fill in the gaps where there may be some gaps in the legislation or the rules, and he does not see any reason why there is not a sort of residual inherent jurisdiction for him to appoint an ETDL even when there is no challenge to the will. And as you said, it allows the parties to take off the gloves, to fight, to be adversarial, to yell and scream while this estate stays neutral. So in this case, the court decided in a case where there was big issues about how the estate had been administered to date, and a sizable estate that justified putting in a corporate trustee, that he was going to do it. So let's jump a couple years. Also, Justice Myers did another decision, which I think is also worth talking about.
So this one is Armstrong v. Laviolette. It's a 2023 decision, ONSC 6783, and I believe it was just released maybe a couple of weeks ago, to be honest. And it was an endorsement from a case conference. And in this case, the estate trustees that were named in the will, who are also the applicants, were looking to bring a dependent support claim, but could not do so while continuing to act as estate trustees because that would be a conflict. There was an alternate estate trustee who potentially also had a conflict in this case because the applicants were trying to increase their share of the assets of the estate at the expense of that alternate estate's share of the residue.
It was the residuary beneficiary. So
Yes.
to the extent that the applicant was claiming to be independent, you're taking away from the residue. So they both had an interest in the outcome of this litigation.
So essentially, no one could act as the estate trustees in this instance. And again, normally an ETDL would be advised in vast majority of cases, as Justice Myers said himself, and Mayor v. Rubin decision. But it was interesting that in this case, Justice Myers took into account the fact that the estate was very small. So he thought that appointing an ETDL would actually completely deplete the estate. And he advised that the parties come back at a different date. And in the meantime, he asked them to consider any other alternative measures to sort of resolve the issue by cooperating and being transparent and maybe, consenting to some preservation orders that might assist resolve the issue without having to resort to appointing an ETDL.
Yeah, listen, a solution that's good for one problem is not necessarily good for another problem. And I think Justice Myers, who obviously has no issue with appointing an ETDL where the circumstances warrant, is not prepared to say in all circumstances, is it appropriate? And I think that as litigators, you see that a lot. You have to deal with each case as you take it. You have to be pragmatic about things. Putting in a corporate estate trustee during litigation who's going to charge hourly rates and minimal charges when you don't have an estate that is that significant, that really doesn't take a lot to be administered. There are other ways to do it. And I really think that Justice Myers was wise to say, I'm not going to jump to that just yet. Why don't we come back? We can talk about whether or not we need to book that kind of motion for an ETDL. But in the meantime, talk about it. There's got to be a better way. I just don't want to make this order and send you off on your way and start incurring those fees and go down this dependent support claim. But there's got to be a better way that's in everyone's best interest. And so I really like that he showed restraint and tried to get the parties to show restraint and talk about it. And let's come back and talk about it again, and we'll see whether or not that makes sense in the circumstances. And yeah, I think there's, as we get to the end of the year, we get to our holiday season, communication has always been the key, right? You've got to talk with people. You've got to find pragmatic ways to deal with difficult problems. And that's what we do. Every problem is different. Every problem has a different solution. And I think that what makes the job interesting is finding creative ways to deal with difficult problems. But I think that concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Margarita Grup.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact page on our website. Have a great day. Have a great holiday season, everybody.
Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hollandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.